Hi everyone, welcome to Thorough Newspaper Analysis. Today is 17th of May and let's start with the video for the day. So let's first have a look at the pointers of discussion for today. In the editorial segment, we have another Indian Express article, and this article particularly it is important for our fraternity. Because here the Supreme Court has said that lawyers, the services that they render, it is not amenable to the provisions of the Consumer Protection Act. The title of this particular article is Supreme Court ruled that a lawyer cannot be sued for providing faulty services. This is a very interesting article, and we'll also have a look at what the court had to say, with respect to the medical professionals being covered by the Consumer Protection Act. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So without further ado, let's start with the article. Let's first have a look at the title of it. Why Supreme Court ruled that a lawyer cannot be sued for providing faulty services under the Consumer Protection Act. Let's first quickly see and have a look at the context, what has happened recently, and then we get into its technicalities and understand the details of this case a bit, elaborately. So the court recently said that a lawyer's services must be treated differently from any other profession, any other business and trade, So what is the court said? Let's get it very clear. Court said that a lawyer's service must be treated and must be kept on a different footing from, let's say, a business or a trade. Supreme Court said this on Tuesday, 14th of May. A bench of Justices, Honorable Justices Bela M. Trivedi and Pankaj Mittal held that the success of professionals as opposed to business and traders often depend on factors which is outside their control, and clients cannot take legal action against their lawyers by claiming that they did not provide proper services as per the Consumer Protection Act. See, what essentially has the court done here is, we'll also have a look at this particular elaboration later as well. But for now, just understand this. The court has drawn a distinction between a business or a trade on the one hand, and on the other hand, on the professionals, those who, are into the practice of, let's say, any particular profession. So the court has said when it comes to professionals like lawyers, there are a couple of, instances, there are a couple of factors which are outside their control. So let's say today, if I am a very qualified lawyer and I have all my concepts of law on tip, I am, recently sound with my practice, everything is well. But still, I cannot say with utmost certainty that I will procure at any cost a winning result for my client. Is it so? Can I say that? The answer here would be absolutely no. Why? Because there are a couple of factors on which the practice of a lawyer depend. It depends on how well your adversary is prepared. It depends upon, what is the current approach of the judiciary with respect to, let's say, that point of dispute. It depends on a couple of factors which are outside the lawyer's, outside the lawyer's control. So therefore, the court has said that the services rendered by a lawyer, a professional, it is different from that of a businessman or a business or a trader, and it cannot be brought into the ambit of Consumer Protection Act. The judgment, it stems, that is to say, it came from an appeal against a 2007 judgment or decision of the National Consumer Dispute Redressal Commission. What did the NCDRC held in 2007? So the National Commission, it stated that the services which is rendered by lawyers, they fall under the definition provided for a term under Section 2, subsection, or to say Clause O. So 2 Clause O of the Consumer Protection Act of 1986. If there is any deficiency in service which is rendered by a lawyer, then the National Commission said that the complaint, that the aggrieved person, the client of the lawyer, can come forward and file a complaint under the Consumer Protection Act. And now that we've understood what was the case and what the Supreme Court has said, let's see what the groups of lawyers have to say on this matter. See, please understand, initially, a lawyer by the name of M. Matthias, he was the original petitioner, And along with him, several other groups were also agitating this particular matter. So who were these other entities? We had the Bar Council of India, the Delhi High Court Bar Association, the Bar of Indian Lawyers. All of them together argued against the application of Consumer Protection Act on legal profession. The majority of their arguments hinged on the idea that legal profession must be differentiated from other businesses and trades, and that even among other professionals, lawyers occupy a very unique space. See, essentially, they were arguing that on the first instance, please mark a very clear distinction between businesses and trades on the one hand and lawyers, professionals on the other hand. Now, within the professionals also, the profession of law, the legal professionals, they occupy a very unique position. Now, why is their position very unique? Let's understand that. So broadly, they had 2-3 arguments to make. One is that a lawyer cannot always be a mouthpiece of their client. So let's say if my client is asking me to do something which is illegal or to adopt unfair means, then I cannot necessarily be a mouthpiece of my client and just do everything that my client asks me to do, because I have other obligations as well towards my profession. I am bound by certain ethics. I am bound by certain rules of practice, which are, let's say, provided in the Bar Council of India rules of 1961. So I cannot always be a mouthpiece of my client. Secondly, they argued that no matter how sound a lawyer may be with his or her practice, knowledge of law, there are always factors which are outside the control of a lawyer. And therefore, a lawyer cannot, with utmost certainty, promise or make a promise with his or her client that, I'm going to secure a win for you. So this is what the petitioners essentially argued, that unlike other professionals, lawyers cannot act as mouthpiece for their clients, even after payment of fee. As lawyers, they have duties to the court and they have duties towards their opponents as well. And this is governed by the Bar Council of India rules of 1961. Further, they argued that these obligations that they have towards their practice, their profession at large, and towards their, let's say, opponents, they are likely to conflict with the duty towards their client. For instance, suppose a lawyer's client comes forward and say that, please adopt such and such unfair means. Now, a lawyer cannot do so because he is under a duty towards the court, and therefore he cannot be a mouthpiece of his client. Secondly, the lawyers argued that lawyers do not have control over the outcome of the case due to the complexity of the legal issues, which often involve very intricate statutes and case laws and often lack a definitive answer. So far we've seen on so many occasions that even the apex court, the most supreme court of our country, the Honorable Supreme Court, they are not bound by their own judgments. They can reverse their own judgments. Let's say in the case of Keshavananda Bharati, certain observations or certain propositions of law which were propounded in the case of Golaknath, they were overruled. So even the top court, has to evolve itself, its understanding of law. So therefore, our profession itself is very uncertain. The subject matter of it is very uncertain. So therefore, there is unpredictability, and it is further fueled by the adversarial nature of legal proceedings, which means that outcome may not depend on your preparation. It may also depend on how well your opponent is prepared. Further, it was argued that unlike the medical profession, where science can help establish a universal standard of care, no such objective standard can be applied across the legal profession. Why? Because each lawyer has his own style of advocacy. There is no set standard scientific technical way of going about things. The petitioners also argued that there are existing remedies for professional misconduct in the Advocates Act itself and the Bar Council, both at the state and the national level. They are given disciplinary powers by the Advocates Act in such cases. So regarding conduct of advocates, the petitioners argued that the Advocates Act would be applied as opposed to the Consumer Protection Act. So let's say if there is an advocate who has conducted himself in such a manner which was not, expected out of a officer of a court, so to say, a member of our fraternity, which is often considered to be, a very noble profession. So then there are mechanisms of dealing with that misconduct, and the mechanism is given itself under the Advocates Act of 1961, and the bar councils, both at the center, the India level and state level, they're given adequate mechanisms to, deal with that indiscipline or misconduct. So why go to the Consumer Protection Act? So although no one appeared to argue on behalf of the respondents, the bench appointed an amicus. Amicus who is an amicus? Amicus is a friend of court. So the amicus here who was appointed is Senior Advocate V. Giri to assist the bench from neutral standpoint. He submitted two arguments broadly. Firstly, he said that there are two categories of lawyers. First up are those lawyers who represent their clients before the court, and therefore, when they represent their clients, they act as the agents of the client. That is, a lawyer is someone, when representing the interest of the client before the court, lawyer is someone who acts as an extension of the client outside the service provider consumer relationship, which is anticipated and envisaged in the Consumer Protection Act. So when the client is represented by the lawyer in his capacity as a practicing advocate in a court, then the Consumer Protection Act will not be applicable. But let's say there is a lawyer who is engaged by a client for out of court work, for let's say drafting a certain document or certain consultation. Then as per the amicus, his services may be covered under the Consumer Protection Act. So now let's see what the court has to say. Did the court, agree on this bifurcation, or did the court outrightly say that no, anything that a lawyer does for the client, it is absolutely outside the purview of the Consumer Protection Act. So here, Justice Bela M. Trivedi authored the main judgment, while Justice Pankaj Mittal offered a concurring opinion here. By concurring, I mean opinion which is not dissenting, which is in conformity with the opinion of Justice Bela M. Trivedi. Justice Trivedi said that there was not a whisper to include the services provided by professionals like lawyers or even doctors when initially the Consumer Protection Act was enacted. And in fact, when the revised Consumer Protection Act was enacted in the year 2019, she drew a distinction between these two. One is the business and trade on one side and the professions on the other side. So it was pointed out by Bela M. Trivedi, Justice Honorable, that for businesses and trades, there is an angle of commercial interest. But when it comes to professionals, they would involve some branch of learning and science. Success in the latter for professionals, it would depend on factors which are beyond a professional's control, and it cannot be treated equally with a businessman or service provider who is covered under the Consumer Protection Act. Now here, this is a very important thing that was pointed out, which we must understand. If you are somebody who is, in touch with, let's say, judgments, or you follow the legal portals or, the verdicts of the Supreme Court and the courts daily, you must have seen that there are a couple of cases which are often invoked against the doctors or medical professionals under the Consumer Protection Act. And they're often, asked to pay compensation. The hospitals are asked to pay compensation for negligent services. So here, Justice Bela Trivedi said that even doctors should not have been included under this. And for that, she drew attention to the judgment of 1995, by virtue of which doctors are covered under the Consumer Protection Act. And she said that it should also be revisited. So this is also an important update. Drawing upon this distinction, she also stated that the Supreme Court's decision in 1995, which is titled Indian Medical Association versus VP Shanta, where the court held that the services of medical professionals would fall under the Consumer Protection Act, it should be revisited by a larger bench. Now, on the unique position of lawyers within professionals also, the court said that it cannot be compared with other professions. Why? Because lawyers, the profession of law, it is not commercial in nature, but it is essentially a service-oriented noble profession. Extending on this limb of argument, She further stated that advocates have to act very fearlessly and independently when protecting the rights of the citizens, judicial independence, and rule of law. So, as a result, the bench held that advocates' action affect not just their clients, but it has a very large repercussion for us, society at large, and hence it has a very unique standing even among professionals. Finally, the bench considered whether advocates enter a contract of personal service with their clients, exempting them from falling under the Consumer Protection Act. So here it was said that the term service, it is defined very widely under the Consumer Protection Act, but it excludes services, free services, and contracts of personal service. The court held that clients exercise a considerable amount of direct control over the advocate services, as an advocate is required to act upon the instructions before they make any concession or undertaking before the court, or which may affect the client's legal rights. Therefore, the advocate and the client, they enter into a contract of personal service. This is very, very important. We also covered it in our legal segment, I believe yesterday or the day before that. So the court said that the contract of client and lawyer, it is in the nature of personal contract, which cannot be a source of challenge under the Consumer Protection Act. And as a result, the verdict of 2007 of the National Consumer Dispute Redressal Commission, it was overturned by the court. So now we proceed to the national news, with this being the first update. Indian Army sets up one of the world's highest tank repair facility near China border. The Indian Army, it has set up two of the world's highest tank repair facilities in Ladakh, close to the line of actual control along China. Kamla, Beniwal, former Gujarat governor, passes away. The Indian political landscape mourns the loss of a pioneering figure. Who is she? It is Kamla Beniwal, who breathed her last on 15th of May at the age of 97. A veteran Congress leader and former governor for the states of Gujarat, Tripura, and Mizoram, she was somebody who had a very long-standing political career that was revered by her colleagues and the political fraternity. Now here I have a question. It would be absolutely great if you could maybe, list down the provisions in the Indian Constitution which provide for the fact that the governor is a part of the executive. And it would be amazing if you could maybe, just list down in which part the state executive is mentioned, what are the article ranges for, let's say, the appointment of governors, or which say that there shall be a governor, and entire, modalities with respect to governor, let's say the appointment, disqualifications, the qualifications, conditions of service, oath, appointment, all of these factors. Next up is this update. Center hands over first set of citizenship documents under the CAA. The central government has finally handed over the first set of citizenship certificates over 2 months after notifying the rules of for the Citizenship Amendment Act. Let's understand what is CAA, which had a very staggering, long-standing protest in Delhi. So the Citizenship Amendment Act of 2019, it was passed by the Parliament of India on 11th of December 2019. It essentially amended the Citizenship Act of 1955, the Parent Act, which deals with all matters with respect to citizenship, along with Constitution, by providing an accelerated pathway to Indian citizenship for persecuted religious minorities from Afghanistan, Bangladesh, and Pakistan who arrived in India by the year 2014. The eligible minorities were stated to be these, which is Hindus, Sikhs, Buddhists, Jains, Parsis, or Christians. Home Ministry extends ban on LTTE by 5 years, citing it as threat to India. So what is LTTE? It is Liberation Tigers of Tamil Eelam. The center has extended the ban which was imposed on this organization, so to say, or entity for a further 5 years term. The Ministry of Home Affairs in its notification said that the central government has taken the decision in view of the activities of the LTTE that continues to pose a threat to the sovereignty and territorial integrity of India. The ministry further cited disruptive separatist and secessionist activities and tendency of this group that are grave threats to the security of Indian nationals as a reason for this particular ban. Please understand that the government had declared this organization as an unlawful association back in May of 2019 and banned it for 5 years. And now the ban has been further extended for a period of 5 years. Another update, which is, in the segment of sports, and again, a very proud moment for us, the undefeatable champion, Neeraj Chopra, he has secured another, sort of an applaud-worthy win for India. Federation Cup 2024, Neeraj Chopra wins Javelin gold with 82.27 meter throw. Neeraj Chopra, the undisputed champion in his category of sport, he's won the Federation Cup for 2024 with the best throw of 82.27 meter on a hot and humid evening, and this happened in Bhubaneswar. The Olympic champion, he made a winning return to competition in India. Soket AI Labs launches Pragna B1 AI model in collaboration with Google Cloud. So let's understand what is this. Homegrown Gen I startup, Soket AI Labs. It has launched India's first open source multilingual foundational model, which is called Pragna B1, in partnership with Google Cloud. This model, it is multilingual. It is available in multiple languages like Hindi, English, Bengali, and Gujarati. The foundational model has been trained on local data and has been designed with the Indian context in mind. Now, with this, we've come to the international segment for today. First up is an update, which is from Slovakia. The Prime Minister of Slovakia, he was shot multiple times. The Slovak Prime Minister, Robert Fico, he was shot multiple times in an assassination attempt. Next up is another update in the international segment. Sea whales returned to Argentina after a century, after a period of almost 100 years. Sea whales, they have been observed in the marine area near Argentina's Patagonian coast. This symbolizing a rebound after years of alarming decline due to historic whaling activities. Let's talk about some of the conservation measures and the recovery. So international measures, including a global ban on commercial whaling, they've helped protect whale species like the one that has just now reappeared, enabling their gradual recovery and return to their former habitats. Now, this has brought us to the legal segment for today, where we have two updates from the Honorable Supreme Court itself. So, in a pivotal judgment, the Supreme Court, while setting aside acquisition of land which was acquired by Kolkata Municipal Corporation, the Supreme Court has highlighted 7 sub-rights of Article 300A of the Indian Constitution. Article 300A, we all know it is the legal right, or to say the constitutional right to property, which was erstwhile a fundamental right. So it provides that no person shall be deprived of his property saved by the authority of law. The judgment was authored by Justice P.S. Narasimha. It stressed that these sub-rights, they mark the legal content of right to property under Article 300A. Let's understand what are these subheads, and then we go back to the observation. First is right to notice. It is the duty of the state to inform the person that it intends to acquire the property. The person whose property is intended to be acquired at the instance of the state must be given a due and reasonable notice. He must be informed of this intent of the government. Secondly, right to be heard. It is the duty of the state to hear objections to this acquisition intention that it has. Thirdly, right to a reasoned decision. It is the duty of the state to inform the person of its decision to acquire the property concerned. Duty to acquire only for public purposes. This is also very essential. It is the duty of the state to demonstrate that this acquiring of the land of this private person, it is for a public purpose. Fifthly, the right to restitution or fair compensation. So the court said that it is the duty of the state to restitute and to rehabilitate. To restitute and rehabilitate, by that we mean that it is the duty of the state to put this person whose property is acquired in closely the same position to which the person was before the acquisition of the property and to pay fair compensation. Sixthly, the right to an efficient and expeditious process. So the court said that it is the duty of the state to conduct the process of acquisition efficiently and within prescribed timeline of the proceedings. Lastly, right of conclusion, which is that the final conclusion of the proceedings leading to vesting. So this is a very important update because here the court has highlighted the sub-rights which are available under the umbrella right of Article 300A, which provides for the protection of right to property. So if the state or the agency of the state is intending to acquire the property of a private person, then there are certain safeguards, there are certain sub-rights within this umbrella right, and these rights are to be complied with and given to the person whose property is acquired or intended to be acquired. The name of this case is Kolkata Municipal Corporation and Other versus Bimal Kumar Shah and others. Another update from the Honorable Supreme Court. So here the Supreme Court has held that fundamental right to health, it includes customers' right to be made aware of quality of products. The Supreme Court has declared that the fundamental right to health, it encompasses, that is to say, it includes within its ambit the right of a consumer to be made aware of the quality of products being offered for sale by the manufacturers, service providers, advertisers, and advertising agencies. To protect this right, the court directed that henceforth, that is to say, from now onwards, prospectively, every advertisement is printed, aired, displayed. Before an advertisement is, printed, aired, or displayed, before it is circulated, put out in the public, a self-declaration shall be made. It shall be submitted by the advertiser or the agency on the lines contemplated by Rule 7 of the Cable Television Networks Rule of 1994. So before you advertise about any product that, so-and-so is our product, this has so-and-so health benefits. So then before you do that, you have to make a self-declaration form saying that, whatever it is that we're advertising, it is correct within the meanings of whatever is required by Rule 7 of the Cable Television Networks rules. You have to make a declaration to that effect. The direction was passed by a bench of Patanjali, which is the Indian Medical Association versus Union of India and others. In the copy of the order, which was uploaded recently, the court made certain pertinent observations regarding consumers' rights. And this is a very important update because you know how there are a couple of products which are out there in the market and offer using influencer marketing. These agencies, they just go about doing anything and, advertising anything. So this is a check upon such practices. The court directed that self-declaration shall be uploaded by the advertiser or the agency concerned here on the Broadcast Seva portal, which is run under the aegis or the control of Ministry of Information and Broadcasting. The name of this particular matter is Indian Medical Association versus Union of India, the Patanjali case. So with this, we come to an end of our TNA. Thank you so much for watching. Have a wonderful day ahead. And also, please don't forget to put down your answers about governors, provisions in the Indian Constitution in the comment section. And you can just, let us know how are you finding the TNAs. If there is any topic that you would want us to discuss, you can put down the same in the comment section. And also, if you found this helpful, the editorial in any way, please don't forget to mention the same in the comment section. Thank you.